If estate planning tools such as statutory powers of attorney or a living trust have not been used to make provisions for the care of minor children or an incapacitated adult, a guardianship for that loved one may be the only remedy. There are three main reasons you would need to set up a guardianship for another person. Number one, a child's parents are deceased. The most tragic situation for when a guardianship is required is when both of a minor child's parents die. As long as one parent is still alive, the surviving parent is the natural guardian of the child without any court involvement needed. However, if both parents perish and no prior planning has designated who they wanted to serve as the guardian of both the person and the estate of the child, someone must apply to a probate court for appointment of such guardians. In this situation, the court has a list of persons who have priority to be appointed as guardian. Some of those persons may be the last people you would want to be serving in those positions. You could end up with grandparents or siblings fighting each other over who should serve as guardians. This can ruin a family relationship and cause extreme stress to the children. Number two, an adult has become mentally incapacitated or incompetent. This is by far the most common reason a guardianship is needed. This situation could have been avoided if you had drawn up statutory power of attorney for the person before your loved one became incompetent. If there is no power of attorney, however, a guardianship is the only answer. An applicant must have a doctor's certificate based on an examination of the person, covering a wide range of areas to determine whether a guardian is needed to handle all of the affairs of the incompetent or incapacitated person, or whether the person is still able to do some things on his or her own. When more than one person may seek to be appointed the guardian, again triggering potential family feuds. And once again, court approval of many actions on behalf of the ward is required, and yearly accountings must be filed as long as the guardianship remains in effect. Once the ward dies, additional accounting and other proceedings are required to close the guardianship. Number three, an adult is functioning with diminished capacity in some area. In this instance, a limited guardianship may be appropriate. A doctor may find the ward, the person in need of a guardianship, only needs assistance in certain areas of functioning, but can make some decisions or take certain actions on their own. Courts favor trying to reserve powers to the ward unless the doctor certifies they are not capable of exercising those powers. The long-term expense of this type of guardianship may be less than a full guardianship, but it is still considerable. If you believe a guardianship is needed for a loved one, please give me a call to discuss the procedure and what is required at 806-220-0150. Thank you.